Good morning to all. Myself, Dr. T. Ramesh Kumar, Assistant Professor, Department of Commerce with Computer Applications, Dr. Drsnsrcas College of Arts and Science. Now we can see the principles of law of contract. In this principle of law of contract, we can discuss about nature of contract. First of all, what is contract? A contract is a legally binding agreement between parties to create mutual obligations that businesses and individuals use to protect their interest. Contracts outline the specific terms of engagement for a transactions. They can also dictate legal consequences if a party tries to break the agreement. Next, how a contract is formed. Offer plus acceptance equal to promise. Promise plus consideration equal to agreement. Agreement plus enforceable by law equal to contract. So next we can see the nature of contract. The nature of contract is that it is the branch of law which determines the circumstances in which promises made by the parties to a contract shall be legally binding on them. It does not lay down the duties and responsibilities which the law will enforce, but it consists a number of limiting principles subject to which the parties may create rights and duties for themselves, which the law will upload. Nature of contract. A contract is an understanding enforceable at law, made between two or more persons, by which rights are acquired on the one side to acts or forbearance on the other. To make an agreement which result in a contract, there must be an offer and an acceptance and promises which stem from the offer and acceptance. The law attaches for the force the obligations. Next, offer and acceptance. Offer, it provides clear, specific, and complete terms. This is nothing but intention to create legal relations. Next, acceptance. Unconditional agreement to the terms of the offer communication of acceptance. It includes silence cannot be treated as acceptance. Next, consideration. It is nothing but something of value exchanged between the parties. Next, capacity. Both parties must have the legal capacity to enter into a contract. Next, we can see consideration. Consideration is a promise, performance, or forbearance bargained by a promiser in exchange for their promise. Consideration is the main element of a contract. Without consideration by both parties, a contract cannot be enforceable. Next, capacity to contract. It is nothing but the primary element of a valid partnership contract is the capability or eligibility of partners to form a business agreement. The capacity to contract here means the legal ability of an individual or an entity to enter into a partnership. According to business law, the partner must be competent and fulfill the specified criteria before signing a contract. The capacity of contract here means the legal ability of an individual or an entity to enter into a partnership. According to business law, The partner must be competent and fulfill the specified criteria before signing a contract. Section 11 of the Indian Contract Act 1972 details the capacity of contract law. It defines the ability to form contracts based on three aspects. They are as follows: attaining specified age, being of sound mind, and not be disqualified from entering into a contract. Next, free consent. It is under the Indian Contract Act is consent that is free from coercion, undue influence, fraud, misrepresentation, or mistake. According to section 13, two or more persons are said to be in consent when they agree upon the same thing in the same sex. Next, legality of object. Legality of an object is the quality of being lawful. This means that an object is legal if it follows the laws set forth by the governing body. Thank you.